Madam Clerk, would you open the courtroom, please?
State of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson, Jr. Good morning, everyone.
Good morning.
Good morning.
All right, we are on the record calling for an objection to garnishment, case number 05140942. The file is entitled ABD Federal Credit Union versus Chantil Jose. Date and time for the objection to garnishment, your respective appearances, please.
Good morning, Your Honor. Andrew Johnston, P79752, on behalf of the plaintiff, ABD Federal Credit Union.
And what is your name, ma'am?
Chantel Jose.
You are the moving party. What is the basis of your objection to garnishment?
Well, I have a lot of different objections to this garnishment. First of all, this particular debt just popped up out of nowhere. I received notification November the 10th to a subpoena that I was supposed to appear via Zoom regarding this debt. On November 10th, I actually Zoomed in. I stayed on there for maybe about 30 minutes. Nobody else came on the Zoom call. I ended up calling the clerk's office, and they told me that the court had been, that they had basically terminated the case because they said they were not able to serve me. So she said, well, you may receive another court date and you may not receive another court date. So I'm like, okay, I'm just waiting for another court date. So she said possibly another court date. So 3 months, fast forward to 3 months, I ended up receiving something in the mail from Michigan First stating that they had, placed a garnishment on my account. So I wasn't even given an ability to even address the debt whatsoever, because I wasn't given the opportunity on November the 10th to say, hey, what is this debt first off? Because I had no idea. I'm like, what is ABD? I've never taken out anything with ABD. Where did this debt come from? So this debt has never appeared on my credit report. When Michigan First sent me over the paperwork, the judgment is actually for 2006. That's 15 years ago. So to my recollection, I'm like, what is going on with this? Is there some type of thing called statute of limitation? Is this debt going to be prolonged? I had no clue what the debt actually is. So after I'm looking, it never appeared on my credit report. I never received anything in the mail. The first time I received something was probably like a year after I purchased my home. And I'm like, okay, I don't know what's going on. Maybe it's something that just came up. Like I said, it never appeared in any of the 3 credit bureaus at all. So I'm like, is this debt even valid? To my knowledge, like I said, I never made an agreement with ABD at all as far as anything.
Do you have any other basis, ma'am, for your objection to garnishment?
I guess just thinking about, is there a certain thing as a statute of limitation on collecting on the debt or collecting on the judgment?
Okay.
I'm sure if the judgment is from 2006, then the actual debt has to be, at least 20 years old or more.
Okay.
Also, I never received anything as far as garnishment. The address that they're sending paperwork to, I haven't lived in that address in probably like 18 months.
Okay.
I'm sorry.
I'm sorry. Is there anything else you want to tell me?
I have some questions about the statute of limitation on collecting on the judgment. Just wondering why, if this debt is so old, why it never appeared on my credit report. Is there a way that they can possibly set aside this judgment and reimburse me my money? Give me an opportunity if this debt is valid, or if it is validated, give me an opportunity to make some type of arrangements regarding this debt.
All right. Let me hear from the plaintiff.
Thank you, Judge. Your Honor, I'm not sure if Your Honor had received our response to defendant's objection to garnishment.
I got the response, although the cover sheet described it as a response to a motion to set aside default judgment. It wasn't
okay.
a response to the objection to garnishment. So you might want to be a little more careful about what you send out.
Okay, I apologize for that, Your Honor. But regarding our response to the objection to garnishment, pursuant to Michigan Court Rule 3.101K, an objection to a garnishment must be based on defects in or the invalidity of the garnishment proceeding itself. In her written objections and in what she's offered to the court today in terms of testimony, Ms. Jose hasn't provided a valid objection to the garnishment under 3.101K. There is a list of several things that would cause the garnishment to be invalid. I don't believe Ms. Jose has provided any of those reasons. Because Ms. Jose has failed to state a valid objection under Michigan Court Rule 3.101K, I would ask for her objections to be denied. Your Honor will also address Ms. Jose's, even though as stated, the objection must be based on the garnishment proceeding itself and not the underlying judgment. I am looking at an order extending judgment signed by Judge Millhouse on December 4th, 2015. So this judgment was in fact extended properly with the court.
Right. Anything else you want to say, ma'am?
No, Your Honor.
Thank you. Court's prepared to rule in this matter. I think what we have here is a failure to understand a couple of basic processes that are going on here. In this case, ma'am, the judgment against you was entered after you were personally served back in December of 2005. A default judgment was entered on February 22nd, 2006. That judgment was renewed by a motion and order granted December 4th, 2015. Basically, a judgment lives for 10 years from the time it is rendered or the time there's a last payment. And inside of that 10-year period, it can be renewed for another 10-year period. That was done here. So your statute of limitations concern is not valid. And I would certainly point out to you, just parenthetically, statute of limitations refers to the commencement of litigation, not the renewal of a judgment. Now, your next objection is that you had no prior notice before the writ of garnishment was served on your credit union. That's exactly the way the procedure is supposed to operate. In regard to the November 10th, 2020 debtor's examination, you were sent notice of that, but that debtor's examination did not proceed for the reason that the that plaintiffs were unable to serve you. And so that had simply not proceeded. In January, they exercised their rights and got a writ of garnishment for non-periodic, that is, a writ that was served on the credit union. The way garnishment works is that when a plaintiff who has a judgment seeks to garnish, whether it's a bank or an employer, they do not serve the defendant. That is, you do not get served. Instead, the plaintiff serves a writ of garnishment on what's called the garnishing defendant. That is, the person or the institution believed to have money that belongs to you. That person or institution has two obligations. One, to advise you that you have been garnished, not the plaintiff, that's the institution that has been garnished. And second, to file a disclosure. Disclosure says, yes, I have money that belongs to the defendant, or no, I do not. So neither of the grounds you have stated for your objection to garnishment are valid. Having failed to state a valid objection to garnishment, your objection to garnishment must be denied. You, of course, have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. The court will send out an order denying the objection to garnishment, and thank you both for coming in. We are off the record.